The Senate will come to order.
Mr. Chief Justice, I have a question for the President's Counsel, and it's co-sponsored by Senators Rounds, Wicker, Ernst, Blackburn, Tillis, Kramer, Cotton, Sullivan, and McSally, all members of the Senate Armed Services Committee.
The Senator from South Dakota, Oklahoma, excuse me. The Senators ask the following question of the Counsel for the President. Mr. Cipollone, as members of the Senate Armed Services Committee, we listened intently when Manager Crow was defending one of Senator Schumer's amendments to the organizing resolution last week, as he explained how he had firsthand experience being denied military aid when he needed it during his service. As you know, David Hale, Undersecretary of State for Political Affairs, confirmed that the lethal aid provided to Ukraine last year was future aid. Which would you say had the greater military impact? President Trump's temporary pause of 48 days on future aid that will now be delivered to Ukraine, or President Obama's steadfast refusal to provide lethal aid to Ukraine for 3 years, more than 1,000 days, while Ukraine attempted to hold back Russia's invasion and preserve its sovereignty?
Mr. Chief Justice, thank you, Senators, for that question. And I think it was far more serious and far more jeopardy for the Ukrainians, the decision of the Obama administration to not use the authority that was given by Congress, that many of you all and many members of the House of Representatives voted for, giving the U.S. government the authority to provide lethal aid to the Ukrainians, and the Obama administration decided not to provide that aid. And multiple witnesses who were called in the House by the House Democrats testified that the United States policy towards Ukraine got stronger under the Trump administration, in part largely because of that lethal aid. Ambassador Yovanovitch, Ambassador Volker, others also testified that U.S. policy in providing that aid was greater support for Ukraine than what was provided in the Obama administration, particularly the provision of Javelin anti-tank missiles, which they explained were lethal and would kill Russian tanks and change the calculus for aggression for the Russians in the Donbass region in the eastern portion of Ukraine, where that conflict is still ongoing. In terms of the pause, the temporary pause on aid here, the testimony in the record, put aside what the House managers have said about their speculation, and they know what it's like to be denied aid. The testimony in the record is that this temporary pause was not significant. Ambassador Volker testified that the brief pause on releasing the aid was, quote, unquote, not significant. And Undersecretary of State for Political Affairs David Hale explained that, quote, this was future assistance, not to keep the Army going now. So in other words, this isn't money that had to flow every month in order to fund current purchases or something like that. It was money, it's 5-year money. Once it's obligated, it's there for 5 years. And it usually takes quite a bit of time to spend all of it. So the idea somehow that during the couple of months in July, August, and up till September 11th, 55 to 48 days, depending on how you count it, that this was somehow denying critical assistance to the Ukrainians on the front lines right then, it's simply not true. And now the House managers have tried to pivot away from that because they know it's not true, and to say, no, it was the signal to the Russians. It was the signal of lack of support that the Russians would pick up on. But here again, it's critical. Even the Ukrainians didn't know that the aid had been paused. And part of the reason was they never brought it up in any conversations with representatives of the U.S. government. And as Ambassador Volker testified, representatives of the U.S. government didn't bring it up to them because they didn't want anyone to know. They didn't want to put out any signal that might be perceived by the Russians or by the Ukrainians as any sign of lack of support. It was kept internal to the U.S. government. They've pointed to some emails that someone at the Department of Defense or Department of State, Laura Cooper, received from unnamed embassy staffers suggesting that there was a question about the aid. But her testimony was she couldn't even remember what the question really was, and she didn't want to speculate. There's not evidence that any decision makers in the Ukraine government knew about the pause. And just the other day, another article came out, I believe it was from at the time, the Foreign Minister, Daniluk, explaining that when the Politico article was published on August 28th, there was panic in Kiev because it was the first time they realized there was any pause on the aid. So that was not something that was providing any signal either to the Ukrainians or the Russians because it wasn't known. It was 2 weeks later, after it became public, that the aid was released. The testimony in the record is that the pause was not significant. It was future money, not for current purchases, and it was released before the end of the fiscal year. They point out that some of it wasn't out the door by the end of the fiscal year. That happens every year. There's some percentage that doesn't make it out the door by the end of the year. And again, it's 5-year money. It's not like it's all going to be spent in the next 30, 60, 90 days anyway. So the fact there was a little fix, Congress passed a fix to allow that $35 million to be spent. Something similar happens for some amount almost every year, and it was not affecting current purchases. It wasn't jeopardizing anything at the front lines. There's no evidence about that in the record. The evidence is to the contrary. Thank you.
Thank you, counsel.
Mr. Chief Justice.
Senator from Maine.
Mr. Chief Justice, I have a question for both sets of counsel, which I'm sending to the desk.
The question from Senator King is for both counsel to the President and the House managers. President Trump's former Chief of Staff, General John Kelly, has reportedly said, quote, "I believe John Bolton," end quote, and suggests Bolton should testify, saying, quote, "If there are people that could contribute to this, either innocence or guilt, I think they should be heard," end quote. Do you agree with General Kelly that they should be heard? I think, counsel for the President, it's your turn to go first.
Thank you, Mr. Chief Justice, members of the Senate. This was a bit of a topic that I discussed yesterday, and that was the information that came out in the New York Times piece about what is purportedly in a book by Ambassador Bolton. Now, as I've said, the idea that a manuscript that's not in the book, there's not a quote from the manuscript in the book, this is a perception of what the statement might be. There have been very forceful statements, not just from the President, but from the Attorney General. The Department of Justice stated that while the Department of Justice has not reviewed Mr. Bolton's manuscript, the New York Times account of this conversation grossly mischaracterizes what Attorney General Barr and Mr. Bolton discussed. There was no discussion of, and this again, personal favors or undue influence on investigations, nor did Attorney General Barr state that the President's conversations with foreign leaders were improper. So again, that goes to just some of the allegations that were in the article. The Vice President said the same thing. He said, in every conversation with the President and Vice President in preparation for our trip to Poland, the President consistently expresses frustration that the United States was bearing the lion's share of responsibility. There's also an interview that Ambassador Bolton had given, I think in August, about the conversation where he said it was a perfectly appropriate conversation. I think that information's publicly available now. So again, to move that into a a change in proceeding, so to speak, I think is not correct. The evidence that has already been presented, a accusation that if you get into witnesses, I'll do this very briefly, if we get down the road on the witness issues, let's be clear. It should not be, I certainly can't dictate to this body, it should certainly not be, though, that the House managers get John Bolton and the president's lawyers get no witnesses. We would expect if they're going to get witnesses, we will get witnesses, and those witnesses would then, but all of that, just to be clear, changes the nature and scope of the proceedings. They didn't ask for it before.
Thank you, counsel.
Senator Justice, what's the significance of the President's former Chief of Staff saying that he believes John Bolton and implicitly does not believe the President, that Bolton should testify? It's really, at the end of the day, not whether I believe John Bolton or whether General Kelly believes John Bolton, but whether you believe John Bolton. Whether you'll have an opportunity to hear directly from John Bolton, whether you have the opportunity to evaluate his credibility for yourself. Now, there are a few arguments made against this. Some are rather extraordinary. It would be unprecedented, the suggestion, I think, is to have witnesses in a trial. What an extraordinary idea. But as my colleagues have said, it would be extraordinary not to. This will be the first impeachment trial in history that involves no witnesses if you decide you don't want to hear from any, that you simply want to rely on what was investigated in the House. That would be unprecedented. Yes, we should be able to call witnesses, and yes, so should the President. Relevant witnesses. Now, the President says that you can't believe John Bolton, and Mick Mulvaney says you can't believe John Bolton. Well, let the President call Mick Mulvaney, another relevant witness with firsthand information. If he's willing to say publicly, not under oath, that Bolton is wrong, let him come and say that under oath. Yes, we're not saying that just one side gets to call witnesses, both sides get to call relevant witnesses. Now, they also make the argument implicitly, well, this is going to take long. Senator's got to warn you, if you run a real trial, it's going to require witnesses, and that's going to take time. And I think the underlying threat, and I don't mean this in a harsh way, but is we're going to make this really time-consuming. The deposition took place very quickly in the House. We have a perfectly good Chief Justice behind me that can rule on evidentiary issues. What's more, the President has waived and waived and waived any claim about national security here by talking about himself, by declassifying the call record. We're not interested in asking John Bolton about Venezuela or other places or other countries, just Ukraine. And if there's any question about it, the Chief Justice can resolve. These are relevant questions to the matter at hand. What you cannot do is use privilege to hide wrongdoing of an impeachable kind and character.
Thank you, Mr. Manager. The Senator from Utah.
I send a question to the desk on behalf of myself and Senators Cruz and Hawley.
The question is directed to counsel for the President. Is it true that Sean Misko, Abigail Grace, and the alleged whistleblower were employed by or detailed to the National Security Council during the same time period between January 20, 2017 and the present? Do you have reason to believe that they knew each other? Do you have any reason to believe that the alleged whistleblower and Misko coordinated to fulfill their reported commitment to, quote, do everything we can to take out the President, end quote?
Mr. Chief Justice, Senators, the only knowledge that we have, that I have of this, comes from public reports I gather that there is a news report in some publication that suggests a name for the whistleblower, suggests where he worked, that he worked at that time while detailed the NSC staff for then Vice President Biden, and that there were others who worked there. We have no knowledge of that other than what's in those public reports, and I don't want to get into speculating about that. It is something that, to an unknown extent, may have been addressed in the testimony of the Inspector General of the intelligence community before Chairman Schiff's committees, but that testimony, contacts with the whistleblower, contacts between members of Manager Schiff's staff and the whistleblower are shrouded in secrecy to this day. We don't know what the testimony of the ICIG was. It remains secret. It has not been forwarded. We don't know what Manager Schiff's staff's contact with the whistleblower have been and what connections there are there. It's something that would seem to be relevant since the whistleblower started this entire inquiry, but I can't make any representations that we have particular knowledge of the facts suggested in the question. We know that there was a public report suggesting connections and prior working relationships between certain people. Not something that I can comment on other than to say that there's a report there. We don't know what the ICIG discussed. We don't know what the ICIG was told by the whistleblower. Other public reports about inaccuracies in the whistleblower's report to the ICIG. We don't know the testimony on that. We don't know the situation of the contacts, coordination, advice provided by Manager Schiff's staff to the whistleblower. That all remains unknown, but something that obviously, to get to the bottom of motivations, bias, how this was all, this inquiry was all created, could potentially be relevant. Thank you.
Thank you, counsel. The senator from New Mexico.
Mr. Chief Justice, I send a question to the desk for the President's counsel.
When did the President's counsel first learn that the Bolton manuscript had been submitted to the White House for review, and has the President's counsel or anyone else in the White House attempted in any way to prohibit, block, disapprove, or discourage John Bolton or his publisher from publishing his book?
Thank you, Mr. Chief Justice, and thank you, Senator, for the question. At some point, I don't know off the top of my head the exact date. The manuscript had been submitted to the NSC for review. It is with career NSC staff for review. The White House counsel's office was notified that it was there. The NSC has released a statement explaining that it has not been reviewed by anyone outside NSC staff. In terms of the second part of the question, has there been any attempt to prevent its publication or to block its publication? I think that there was some misinformation put out into the public realm earlier today, and I can read for you a relatively short letter that was sent from NSC staff to Charles Cooper, who is the attorney for Mr. Bolton, on January 23rd, which was last week. Which says, "Dear Mr. Cooper, thank you for speaking yesterday by telephone. As we discussed, the National Security Council Access Management Directorate has been provided the manuscript submitted by your client, former Assistant to President John Bolton, for pre-publication review. Based on our preliminary review, the manuscript appears to contain significant amounts of classified information. It also appears that some of this classified information is at the top secret level, which is defined by Executive Order 13526 as information that, quote, reasonably could be expected to cause exceptionally grave harm to the national security of the United States if disclosed without authorization. Under federal law and the non-disclosure agreements your client signed as a condition for gaining access to classified information, the manuscript may not be published or otherwise disclosed without the deletion of this classified information. The manuscript remains under review in order for us to do our best to assist your client by identifying the classified information within the manuscript, while at the same time ensuring the publication does not harm the national security of the United States. We will do our best to work with you to ensure your client's ability to tell his story in a manner that protects U.S. national security. We will be in touch with you shortly with additional, more detailed guidance regarding next steps that should enable you to revise the manuscript and move forward as expeditiously as possible. Sincerely, and then the signature of the career official. So it is with the NSC doing their pre-publication review. Through his lawyer, Ambassador Bolton was notified that the manuscript he submitted contains a significant amount of classified information, including at the top secret level, so that in its current form, it can't be published, but that they will be working with him as expeditiously as possible to provide guidance so it can be revised and so that he can tell his story. And that was the letter from the NSC that went out. Thank you.
Thank you, counsel.
Mr. Chief Justice.
The senator from Iowa.
Mr. Chief Justice, I send a question to the desk on behalf of myself and Senators Burr, McSally, Daines, Moran, Young, and Sass.
The senator's question is directed to counsel for the president. Is it true the Trump administration approved supplying Javelin anti-tank missiles to Ukraine? Is it also true this decision came on the heels of a nearly 3-year debate in Washington over whether the United States should provide lethal defense weapons to counter further Russian aggression in Europe? By comparison, did President Obama refuse to send weapons or other lethal military gear to Ukraine? Was this decision against the advice of his defense secretary and other key military leaders in his administration?
Mr. Chief Justice, thank you, Senators, for the question. Yes, the Trump administration made the decision to provide Javelin anti-tank missiles, and there was a significant debate about that for some time. Authorization had been granted by Congress, and many of you voted for that statutory authorization during the Obama administration to provide lethal assistance to Ukraine. But the Obama administration decided not to provide that. It was only the Trump administration that made that lethal assistance available. And there was a significant amount of testimony in the House proceedings that President Trump's policy towards Ukraine was actually stronger. Ambassador Volker explained that America's policy toward Ukraine has been strengthened under President Trump, and that each step along the way in the decisions that got to the Javelin missiles being provided was made by President Trump. It is something that has substantially strengthened our relationship with Ukraine and strengthened their ability to resist Russian aggression. Ambassador Yovanovitch said that President Trump's decision to provide lethal weapons meant that our policy actually got stronger over the last 3 years, and she called it very significant. In another point to make in relation to this is, again, that the temporary pause that took place over the summer is something that the Ukrainian Deputy Defense Minister described as being so short that they didn't even notice it. So President Trump's policies across the board have been stronger than the prior administrations in providing defensive capability, lethal defensive capability, to the Ukrainians. And I think that that's significant. The specific part of the question, Senators, whether it was contrary to the advice of the President's Defense Secretary and others, I believe that that is accurate. It was against the advice of the Secretary of Defense. It was President Trump's decision to provide this lethal assistance, and that has been made public in the past. Thank you.
Thank you, counsel. Senator Feinstein.
Thank you, Mr. Chief Justice. I send a question to the desk on behalf of Senator Carper, Coons, Hirono, Leahy, Tester, Udall, to the House managers, and on behalf of myself. Thank you.
Senator Feinstein and the other senators is to the House managers. The President has taken the position that there should be no witnesses and no documents provided by the executive branch in response to these impeachment proceedings. Is there any precedent for this blanket refusal to cooperate, and what are the consequences if the Senate accepts this position here?
Mr. Chief Justice and Senators, President Trump has taken really an extreme measure to hide this evidence from Congress. No president has ever issued an order to direct a witness to refuse to cooperate in an impeachment inquiry before this. Despite his famous attempts to conceal the most damaging evidence against him, even President Nixon allowed senior officials to testify under oath. Not only did he allow them, he told them to go to Congress voluntarily and answer all relevant questions truthfully. But President Trump issued a blanket order directing the entire executive branch to withhold all documents and testimony from the House of Representatives. This order was categorical, it was indiscriminate, unprecedented. Its purpose was clear: to prevent Congress from doing its duty under the Constitution to hold the president accountable for high crimes and misdemeanors. Telling every person who works in the White House and every person who works in every department, agency, and office of the executive branch is just not precedented. It wasn't about specific, narrowly defined privileges. He never asserted privileges. And the President's counsel has mentioned over and over that he had some reason because of the subpoenas. Well, I'll tell you, we adopt rules about subpoenas in the House. The Senate is a continuing body, but the House isn't. And in January, we adopted our rules, and it allows the committee chairman to issue subpoenas. And that's what they did. He refused to comply with those subpoenas, not because he exerted executive privilege, because he didn't like what we were doing. He tried to say it was invalid, but it was valid, and actually he doesn't have the authority to be the arbiter of the rules of the House. The House is the sole arbiter of its rules when it comes to impeachment. Now, this refusal to give testimony documents, it's still going on. We still have former or current administration officials who are refusing to testify. We would not allow this in any other context. If a mayor said, I'm not going to answer your subpoenas, they'd be dealt with harshly if it was to cover up misdeeds and crimes as we have here. So mayors have actually gone to jail for doing that. If we allow the president to avoid accountability by simply refusing to provide any documents, any witnesses, unlike every single president who preceded him, we're opening the door not just to eliminating the impeachment clause in the Constitution, Try doing oversight. Try doing oversight, senators, and we're thinking about that in the House. If the president can just say, we're not sending any witnesses, we're not sending any documents, we don't have to, we don't like your processes, we have a wholesale rejection of what you're doing. That's not the way our Constitution was created, where each body has a responsibility. There's a sharing of power. And I know you, cherish the responsibility that we have. That will be eviscerated if the president's complete stonewalling is allowed to persist and be accepted by this body. You have to act now in this moment of history. I yield back.
Thank you.
Mr. Chief Justice.
Senator from West Virginia.
Thank you. I send a question to the desk for the President's Counsel.
The senator's question is for counsel for the president. You said that Ukrainian officials didn't know about the pause on aid until August 28, 2019, when it was reported in Politico. But didn't Laura Cooper, the Deputy Assistant Secretary of Defense for Russia, say that members of her staff received queries about the aid from the Ukrainian embassy on July 25? Does that mean that Ukrainian officials knew about the hold on aid earlier than the Politico article?
Mr. Chief Justice. Members of the Senate, Senator, thank you for your question. It does not mean that. As we explained on Saturday, the overwhelming body of evidence indicates that the Ukrainians at the very highest levels, President Zelensky and his top advisors, only became aware of the pause in the security assistance through the August 28 Politico article. I addressed on Saturday, and so those comments will stand, the emails from the Deputy Assistant Secretary of Defense, Laura Cooper, testified about previously. What she had said was that her staff had gotten emails from someone at the State Department who had had some sort of conversation with Ukrainian officials here that somehow related to the aid at a time prior to August 28. She did not know the substance of the emails, nor whether they mentioned hold, pause, review, anything of that nature. And she even said herself that she didn't want to speculate as to what the emails mean and cannot say for certain what they were about. I presented on Saturday the evidence, which again, referencing the common sense that would be in play here. This was something that on August 28th caused a flurry of activity among the highest-ranking Ukrainian officials. Never before did they raise any questions at any of the meetings they had with the high-ranking U.S. officials through July and August. There were meetings on July 9, July 10, July 25 call, July 26, and August 27. At none of those meetings was the pause on aid revealed or inquired about. However, as soon as the Politico article came out on August 28th, within hours of that Politico article coming out, Mr. Yermak texted the article to Ambassador Volker and asked to speak with him. That's consistent with someone finding out about it for the first time. The Ukrainians have also made statements that they learned about it for the first time, and then Mr. Philbin just referenced an article that came out yesterday in the Daily Beast, which was an interview with Mr. Daniluk, who was at the time a very high-ranking defense official with the Ukrainians. And this is interesting, and I'm going to read this article because I think it's important, and I suggest it to the Senate if they wish to have something to consider further on this. Daniluk said he first found out that the U.S. was withholding aid to Ukraine by reading Politico's article published August 28. U.S. officials and Ukrainian diplomats, including the country's foreign minister, Elena Zerkal, have said publicly that Kiev was aware that there were problems as early as July. And that's the article that they've mentioned in the statement that the House members have mentioned. Here's Mr. Daniluk. I was really surprised and shocked because just a couple of days prior to that, I actually had a meeting with John Bolton. Actually, I had several meetings with him, and we had extensive discussions. The last thing I'd expected to read was an article about military aid being frozen, Daniluk said. After that, I was trying to get the truth. Was it true or not true? Daniluk said that it was a panic inside the Zelensky administration after the initial news broke, saying Zelensky was convinced there had been some sort of mistake. That's President Zelensky. Daniluk put in calls to the National Security Council, and asked other officials in Washington what to make of the news, again on August 28th, or right after August 28th. The next time we met in September, it was in Poland for the commemoration of the beginning of the Second World War, the Warsaw meeting we've discussed previously. Daniluk said, adding that he met with Bolton on the sidelines of the commemoration. I had my suspicions. There was a special situation with one of our defense companies that were acquired by the Chinese, and the U.S. was concerned about this. Bolton actually made the public comments about this as well. So somehow I linked this to things and tried to understand, okay, maybe this could be related to this. So not only did they not know until August 28th, when they did find out, they didn't link it to any investigations. Where's the quid pro quo? If this is such the forefront of their minds, such pressure on them that the Ukrainians have to do these investigations to get the aid, when the aid was held up, they didn't think it was connected to the investigations.
Thank you, counsel.
Thanks, Mr. Chief Justice.
The senator from Maryland.
Mr. Chief Justice, I have a question on behalf of Senator Baldwin and myself I sent to the desk.
The question is addressed to the House managers. Is the White House correct in its trial memorandum and in presentations of its case that, quote, President Zelensky and other senior Ukrainian officials did not even know that the security assistance had been paused, end quote, before seeing press reports on August 28, 2019, which was more than a month after the July 25 phone call between Presidents Zelensky and Trump?
Thank you, Chief Justice and Senators, for the question. The answer is no. The evidence does not show that. We know that Defense Department official Laura Cooper testified that her staff received 2 emails from the State Department on July 25th revealing that the Ukrainian embassy was, quote, asking about security assistance. And in fact, counsel for the president brought up these emails just now. So I would propose that the Senate subpoena those emails so we can all see for ourselves what exactly was happening. We also know that career diplomat Catherine Cross stated that she was, quote, very surprised at the effectiveness of my Ukrainian counterparts' diplomatic tradecraft, as in to say they found out very early on or much earlier than I expected them to, end quote. And that Lieutenant Colonel Alex Vindman testified that by mid-August he was getting questions from Ukrainians about the status of security assistance. So the evidence shows over and over again from the House inquiry that there was a lot of discussion, and there should be. Because we also know that delays matter. They matter a lot. And you don't have to take my word for it. This is not just about a 48-day delay. The Ukrainians were consistently asking about it because it was urgent. They needed it. They needed it, and who else was asking for it was American businesses. The contractors who are going to be providing this were also making inquiries about it because there's a pipeline. And as my esteemed Senate Armed Services colleagues know very well, that providing aid is not like turning on and off a light switch. You have to hire employees. You have to get equipment. You've got to ship it. It takes a long time for that pipeline to go. And in fact, I had to come together as a Congress to pass a law to extend that timeline because we were at risk of losing it. And to this day, $18 million of that aid have still not been spent. But let's just assume for a minute, also broadly speaking, that the President's Council's argument that support for Ukraine has never been better than it is today. That under the Trump administration, they are the strongest ally the Ukraine has seen in years. So just assuming for a minute that argument to be true, it kind of makes our own argument. It kind of makes our argument. Then why hold the aid? Why hold the aid? Because nothing had changed in 16, nothing had changed in 17, nothing had changed in 18. One thing had changed in 19, and that was Vice President Biden was running for president. Lastly, the question before by my Senate Armed Services colleagues framed this in terms of the military impact. And they asked what was greater in terms of military impact, not providing lethal aid or a 48-day delay. Let's not forget the reason for the delay, because there's a lot of discussion today about the technicalities of the delay, and that the president's mentality, his mindset doesn't matter. It doesn't matter what he intended to do. But I would posit that's exactly why we're here. That it does matter what the president intended to do, because the American people, in matters of national security, deserve to go to bed every night knowing that the president, the commander-in-chief, the person who is ultimately responsible for the safety and security of our nation every night, has the best interests of them and their families in this country in mind, not the best interests of his political campaign. And that is why we are here.
Mr. Manager.
Mr. Chief Justice.
Senator.
I sent a question to the desk on behalf of myself and Senator Murkowski.
The question is to counsel for the President. Witnesses testified before the House that President Trump consistently expressed the view that Ukraine was a corrupt country. Before Vice President Biden formally entered the 2020 presidential race in April 2019, did President Trump ever mention Joe or Hunter Biden in connection with corruption in Ukraine to former Ukrainian President Poroshenko or other Ukrainian officials, President Trump's cabinet members or top aides or others? If so, what did the President say to whom and when?
Mr. Chief Justice, Senators, thank you for that question. Of course, I think it's important at the outset to frame the answer by bearing in mind I'm limited to what's in the record, and what's in the record is determined by what the House of Representatives sought. It was their proceeding. They were the ones who ran it. They were the ones who called the witnesses. So part of the question refers to conversations between President Trump and other cabinet members and others like that. There's not something in the record on that. It wasn't thoroughly pursued in the record. So I can't point to something in the record that shows President Trump at an earlier time mentioning specifically something related to Joe or Hunter Biden. It is in the record that he spoke to President Poroshenko twice about corruption in the Ukraine, both in June of 2017 and again in September of 2017. But there is other information publicly available and in the record that I think is important for understanding the timeline and understanding why it was that the information related to the Bidens and the Burisma affair came up when it did. So one important piece of information to bear in mind is President Poroshenko was the person that Joe Biden himself, on the tapes we've seen, went to have the prosecutor fired. So as long as President Poroshenko was still in charge in Ukraine, he was the person that Joe Biden had spoken to get the prosecutor, Shokin, fired when Shokin was looking into, according to public reports, looking into Burisma. As long as he was still the president in Ukraine, questioned the utility of raising an incident in which he was the one who was taking the direction from Vice President Biden to fire the prosecutor. So when you have an election in April of 2019, and you have a new president, President Zelensky, who is run on an anti-corruption platform, and there is a question, is he really going to change things? Is there going to be something new in the Ukraine? It opens up an opportunity to start looking really at anti-corruption issues and raising questions. Now, the other important thing to understand in the timeline is that we've heard a lot about Rudy Giuliani, the president's private lawyer, and what was he interested in Ukraine, and what was his role? Well, as we know, it's been made public, Mr. Giuliani, as the president's private lawyer, had been asking a lot of questions in the Ukraine dating back to the fall of 2018. And in November 2018, he said publicly he was given some tips about things to look into. He gave a dossier to the State Department in March of this year. Remember, Vice President Biden announces his candidacy in April 25th. In March, Rudy Giuliani gave documents to the State Department, including interview notes from interviews he conducted both with Shokin and with Yuri Lutsenko, who was also a prosecutor in the Ukraine. And those interview notes are from January 23rd and January 25th, 2019, so months before Vice President Biden announced any candidacy. And it goes through in these interview notes, Shokin explaining that he was removed at the request of Mr. Joseph Biden, the Vice President. And it explains that he had been investigating Burisma and that Hunter was on the board. And it raises all of the questions about that. So it was Mr. Giuliani who had been, as Jane Raskin explained the other day as counsel for the president here, Mr. Giuliani, as counsel for the president, is looking into what went on in Ukraine. Is there anything related to 2016? Are there other things related there? And he's given this information, tips about this, and starts pursuing that as well. And he's digging into that in January of 2019. We know that Mr. Giuliani is the president's private counsel. I can't represent specific conversations they had. They would be privileged. But we do know from testimony that the president said in a May 23rd Oval Office meeting with respect to Ukraine, talk to Rudy. Rudy knows about Ukraine. So the president, it seems from that, gets information from Mr. Giuliani. Months before Vice President Biden announced his candidacy, Mr. Giuliani is looking into this issue, interviewing people and getting information about it. In addition, in March of 2019, articles began to be published. Then 3 articles were published by ABC, by The New Yorker, and by The Washington Post before the July 25th call. Washington Post on July 22nd, 3 days before the call, has an article specifically about the Bidens and Burisma. That's what makes it suddenly current, relevant, probably to be in someone's mind. So that's the timeline.
Mr. Chief Justice.
Senator from California.
Thank you. I sent a question to the desk on behalf of Senator Patty Murray and myself.
Senator Harris and Murray ask the House managers. The House of Representatives is now in possession of a tape of President Trump saying of Ambassador Maria Yovanovitch, quote, "Get rid of her, get her out tomorrow. I don't care, get her out tomorrow, take her out, okay, do it," end quote. President Trump gave this order to Lev Parnas and Igor Fruman, 2 men who carried out Trump's pressure campaign in Ukraine at the direction of Rudy Giuliani. Does the discovery of this tape suggest that if the Senate does not pursue all relevant evidence, including witnesses and documents, that new evidence will continue to come to light after the Senate renders a verdict?
The answer is yes. What we have seen really over the last several weeks since the passage of the articles in the House of Representatives is every week, indeed, sometimes every day, there is new information coming to light. We know there's going to be new information coming to light on March 17th when the Bolton book comes out. That is, if the NSC isn't successful in redacting it or preventing much of its publication. And on that issue, I do want to mention one other thing in response to the question about the Bolton manuscript and what did the White House lawyers know. Because I listened very carefully to the answer to that question, and maybe you listened more carefully than I did. What I thought I heard them say in the answer to that question, what did they know about the manuscript and when did they know it? Their statement was very precisely worded. The NSC unit reviewing the book did not share the manuscript. Well, that's a different question than whether the White House lawyers found out what's in it. Because you don't have to circulate the manuscript to have someone walk over to the White House and say, you do not want John Bolton to testify. Let me tell you, you do not want John Bolton to testify. You don't need to read his manuscript because I can tell you what's in it. So the denial was a very carefully worded one. I don't know what the White House lawyers knew and when they knew it, but they did represent to you repeatedly that the president never told a witness that he was freezing the aid to get Ukraine to do these investigations. And we know that's not true. You know that from the witnesses we've already heard from, but we also know, at least if the reporting is correct, and you should find out if it is, that John Bolton tells a very different story. So there are going to continue to be revelations, and members of this body on both sides of the aisle are going to have to answer a question each time it does, why didn't you want to know that when it would have helped inform your decision? In every other trial in the land, you call witnesses to find out what you can. Again, we're not a court of appeals here. We are the trial court. We're not confined to the record below. There is no below. Counsel says, in answer to the senator's question about whether Donald Trump ever brought up the Hunter Biden problem with President Poroshenko in the past, and says, well, we're confined to the record before us. You're not confined to the record in the House, nor is the president. The president could call witnesses if they existed. There's nothing to prevent them from saying, as a matter of fact, tomorrow we're going to call such and such, and they're going to testify that indeed Donald Trump brought up Hunter Biden to President Poroshenko. There's nothing prohibiting them from doing that. But at the end of the day, we are going to continue to see new evidence come out all the time. But among the most significant evidence, we know what that's going to be. And, you know, the effort to suggest that, well, because this president was stronger on javelins than his predecessor, when we know from the July 25th call, the moment that Zelensky brings up the javelins, what's the very next thing the president says? He wants a favor. The question is, why did he stop the aid?